People always want to know if I see a lot of emergencies in my practice. And the answer is really no. We consider an emergency to be someone has died or is mortally injured. One occasion when I did see a serious emergency, I received a call at like 6:30 on a Thursday night, and it was from a lawyer who had a frantic potential client who needed our help. And he called my cell phone and I spoke with him, and it turned out that this client's spouse was on life support at a hospital and had been told that the hospital was going to withdraw life support if there was no court intervention, because this was during COVID and this healthy 40-something person had fallen sick with COVID and was at death's door. And the spouse just could not believe that this healthy, vital person had deteriorated to the point of near death so quickly. So I was retained at like 10 o'clock at night, and I immediately filed an emergency motion for an injunction to stop the hospital from withdrawing life support so that the spouse could at least get a second opinion about the other spouse's mental status. As soon as I filed the motion at like 10 p.m., I got a phone call on my cell phone from the emergency duty judge. And he advised me that the filing needed to be made in the probate division instead of the civil division. So I immediately filed the motion in a different format in the probate division. And at 7 a.m. I got another call from the emergency duty judge in that division letting me know that it needed actually to be in the mental health division. So I filed it a third time in mental health. By this time, the regular duty judge had gotten a hold of my original motion in Circuit Civil Court, and that was Judge Martin Zilber, who is no longer on the bench. And his judicial assistant called me at 10:30 in the morning and said, "My judge told me there's no such thing as an emergency in civil court, except this is a real emergency." So fortunately, we were able to get an injunction entered by 11 o'clock the next day. So within 12 hours of being retained, I had an injunction. We immediately served the attorney for the hospital, who I coincidentally went to law school with and personally knew. And that enabled us to preserve the spouse's life and move forward with his care. So that was a true emergency. Ordinarily, we might consider it an emergency also if a person was looking at their bank account and watching it be drained for some reason, or funds get frozen. And if there is something like that happening, we might be able to move at as fast a pace as we did involving the life support example. But the problem with money losses is that they can be restored with money. And anything that can be repaired or restored with money is not considered an emergency in the eyes of the law. It has to be something priceless like life or physical health or some historical artifact or location, like a historic building can be stopped from being torn down, or an archaeological site with historical significance can be protected. So if you think you have an emergency, consider these pieces of advice. Number 1 is someone about to die. Number 2 is someone in mortal danger of injury. And number 3 is a priceless, irreplaceable object at risk. And if none of those three things are true, then odds are you don't really have an emergency. That said, when people feel they have an emergency, at our firm we accommodate them by offering an emergency consultation as early as 7 in the morning and as late as 7 at night. But because it is so unusual, we do charge a premium fee for those emergency consultations.